This is an absolute win for Donald Trump, not just the substance of the opinion, but also the court had the option here to make the decision effective immediately or go through a traditional waiting period of 25 days. There's no expedited period. This effectively grants Donald Trump blanket immunity because it makes it seems to me now, impossible for a trial to go forward, either in the classified documents case, because this is also at stake there, and the January 6th case. And I think when you look at the dissenting opinion, Devin read part of it. This line stands out to me. Says the decision, quote, makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law.
Hi friends, Adam is here. So stop, what are you doing? This has just happened. The Supreme Court's immunity decision was a get-out-of-jail-free card for Donald Trump. You are only reading the headlines. And the headlines, as usual, are designed to distract you from the real story unfolding in the shadows of the federal courthouse. What's actually happening is a methodical, almost surgical takedown of Trump's legal defenses, one piece of evidence at a time. It's not a total victory. It's a slow-motion dismantling.
In our Law and Justice lead, the U.S. Supreme Court earlier today ruled that Donald Trump is entitled to some immunity from criminal prosecution for acts he took, official acts, when he was president, and now the lower courts must decide which acts are official, which are not, which means that Trump's January 6th case is unlikely to happen before November's election, if at all. CNN's Paula Reed has more on how we got to today's ruling.
Presidents have to be given total immunity. They have to be allowed to do their job.
The Supreme Court partially siding with former President Donald Trump in his ongoing January 6th case, ruling that former presidents are entitled to some immunity from prosecution for official actions, but not for private conduct.
Lower court judges are taking the Supreme Court's own rulebook, the framework the justices handed down, and using it to carve away the immunity shield from the most damning parts of the January 6th conspiracy. This isn't happening in one dramatic moment. It's happening act by act, allegation by allegation, in the quiet, relentless grind of legal procedure. And the consequences? They are far more devastating for Trump than the initial ruling ever suggested. The real story is a legal masterpiece of irony, where the very decision meant to protect him is now being wielded as the instrument to expose him. Let's go back to July 1st, 2024. The Supreme Court dropped its decision in Trump versus United States. The headline was a 6-3 conservative majority declaring that former presidents have absolute immunity for their core constitutional duties.
In the 6-3 opinion, Chief Justice John Roberts, writing for the majority, at least with respect to the president's exercise of his core constitutional powers, this immunity must be absolute. The president enjoys no immunity for his unofficial acts, and not everything the president does is official. The president is not above the law. The High Court, though, leaving it up to lower courts to determine which actions are official and therefore immune. Roberts writing other allegations, such as those involving Trump's interactions with the vice president, state officials, and certain private parties, and his comments to the general public, present more difficult questions. Meaning District Court Judge Tanya Chutkan, who is overseeing Trump's January 6th case, will need to decide.
Things like issuing pardons or running the Justice Department. They also said there's a layer of presumptive immunity for anything within the outer perimeter of official duties. But here's the part that got buried. They said there is zero immunity for unofficial acts, private conduct, campaign behavior, anything done as a candidate, not as president. The court also took a sledgehammer to Trump's wilder argument, the one where he claimed he couldn't be prosecuted for anything unless he was first impeached and convicted. They shut that down completely, calling it a far broader immunity than anything they were willing to recognize. Then came the kicker. They didn't just say Trump wins. They vacated the lower court's ruling and sent the whole case back to District Judge Tanya Chutkan with a simple instruction. Go through the indictment, allegation by allegation, and sort it out. Which acts are official? Which are private? This was the Supreme Court effectively saying, we're not giving him a pass. Go figure out the details. And that's where the trap was set. because what has happened since that remand is a slow-motion catastrophe for Trump's legal strategy. Judge Chutkan and other courts have been doing exactly what the Supreme Court ordered. They've been taking the most operationally specific, most evidence-rich parts of the January 6th case and placing them squarely in the unofficial column. The fake elector scheme? Unofficial. The pressure campaign on state officials to find votes? Unofficial. The secret meetings with private campaign lawyers plotting to disrupt the certification? Unofficial. Each of these acts, the ones with the most documentation, the most witnesses, the most damning paper trails, is being stripped of immunity. The wall Trump thought he built around himself isn't holding. It's being chipped away, brick by brick, right where the evidence is strongest. And Trump's reaction? It's the reaction of a man watching his fortress crumble. He's not calmly filing appeals. He's lashing out, attacking the judges, screaming about foreign influence, demanding the impeachment of any judge who rules against him. This isn't a legal strategy. It's a meltdown. It's the documented rage of a defendant who understands that the immunity shield he was counting on is dissolving in the very places he can least afford to lose it. This is the story we're breaking down today. The quiet, systematic destruction of Trump's immunity defense and the total meltdown that's following in its wake. Stay with me. To understand why this is such a big deal, you need to grasp the anatomy of that remand. The Supreme Court didn't just give Trump a win and walk away. They handed Judge Chutkan a scalpel and said, "Cut." They created a framework that forces a specific question to be asked about every single alleged act. Was this action taken as the chief executive wielding the constitutional power of the presidency? Or was it taken as a private citizen, a candidate desperate to hold on to power? In theory, that sounds simple. But in practice, it's a legal minefield. Directing the Justice Department? That's official. Using the White House communications apparatus? That leans official. But calling up a state election official through a campaign cell phone? That's private. Meeting with campaign lawyers in a private office to hatch a plan? That's private. Organizing fake electors through political operatives? That's private. The line between official and unofficial is drawn not by the title of the person, but by the channel they use to do it. And the most damning pieces of the January 6th puzzle, the ones with the emails, the texts, the recordings, the witnesses, were all implemented through private campaign channels, which means the evidence that is most powerful is also the evidence that is least protected. Legal groups like the ACLU warned that the ruling would put presidents above the law for official acts, and that's a genuine long-term concern. It means a president could theoretically use the pardon power or the DOJ for corrupt purposes and face no criminal consequences. That's the alarming precedent for the future. But for the present, right now, in the Trump case, the framework is being applied in the exact opposite way Trump wanted. It's being used to expose his most specific conduct to full prosecution. So let's dig into the three dimensions of this story. First, we need to look at the specific acts that are landing in the no immunity zone and why that's devastating. Second, we have to understand the official acts that are protected and why that's a separate problem for the future. And third, we need to analyze Trump's meltdown as the behavioral evidence of a losing legal battle. Let's start with the fake elector scheme. This is the single most important example of the immunity framework backfiring. The plan was simple. In states Joe Biden won, Trump's team would create their own slates of electors and submit them to Congress, creating chaos and a pretext for Mike Pence to reject the legitimate results. Now ask yourself, who organized this? It wasn't the Department of Justice. It wasn't a formal government agency. It was campaign operatives, private lawyers like Rudy Giuliani and John Eastman. The communications weren't on official White House servers. They were on personal emails and encrypted apps. The entire operation was a private political project, not a governmental one. Under the Supreme Court's framework, that makes it unofficial. Period. And because it's unofficial, there's zero immunity. The evidence documenting this scheme, the emails, the recordings of meetings, the testimony from participants, is some of the most detailed and corroborated in the entire case. So not only is it the most damaging evidence, it's also the evidence with the weakest legal protection. That's the irony. The more specific the conduct, the more it looks like a campaign stunt, the more exposed it becomes. Next, look at the state official pressure campaign. This is the part of the case that most people know because of the phone call. The one to Georgia Secretary of State Brad Raffensperger. The call where Trump said, "I just want to find 11,780 votes." That call was recorded. We know exactly what was said. So the question for the court wasn't whether it happened. It was whether it was official or unofficial. Was Trump acting as president, exercising some kind of federal authority over state elections? No. There's no law that gives a president the power to direct a state's Secretary of State on how to certify votes. Was he using official government channels? No. The call was arranged through campaign aides, not the White House switchboard. It was a candidate using political leverage to pressure a state official. Under the immunity framework, that's clearly unofficial. And because it's unofficial, it's fully prosecutable. The most emotionally powerful piece of evidence in the entire case, the one that's been played on loop for the public, is the one that has no immunity protection whatsoever. Then there are the private campaign lawyer meetings. This is where the plot to disrupt the certification was actually crafted. John Eastman, Rudy Giuliani, and others, these weren't White House counsel. They were private attorneys brought in through the campaign. They were operating outside any official governmental structure. Their memos, their strategy sessions, their coordination with state legislators, all of it was done in a private capacity. That means all of it falls into the unofficial category. The evidence from these meetings, including Eastman's own emails where he acknowledged the plan might be illegal, is now fully exposed. There's no immunity shield protecting it. The framework the Supreme Court set up forces these specific, documented acts into the prosecutable zone. Now, let's talk about the other side of the coin, the official acts. Because this is where the ruling is genuinely alarming for the long term, even as it hurts Trump in the short term. The absolute immunity for core official acts, pardons and DOJ direction, is a massive problem for presidential accountability moving forward. What does that mean? It means if a future president uses the pardon power to protect co-conspirators, they can't be prosecuted for it. If a future president orders the Justice Department to investigate a political rival or shield an ally, they can't be prosecuted for that either. That is the dangerous precedent that legal scholars are rightly worried about. It's a blank check for corruption within those specific powerful functions of the executive branch. So while the immediate application of the framework is stripping Trump of immunity for his January 6th conduct, the long-term damage to the rule of law is embedded in those core official act protections. It's a ruling that gives future presidents a license to abuse their most powerful tools. But let's bring it back to the meltdown, because that's where the story gets real. Trump's reaction to these line-drawing findings is the most revealing evidence we have about what his legal team actually thinks is happening. When judges rule against him, he doesn't just appeal, he attacks. He calls them wacky, nasty, crooked. He accuses them of being under foreign influence. He's launched a campaign to impeach the judges who make these adverse rulings. This isn't just bluster. This is a documented behavioral pattern. A defendant who believes his immunity arguments are solid doesn't need to destroy the judges. He can just wait for the appeal. An appeal is designed to fix legal errors. So why is Trump acting like a cornered animal? Because his lawyers know the truth. They know that the Supreme Court's framework isn't being misapplied. It's being applied correctly. And it's placing the most specific, most documented parts of the case outside the immunity protection. The meltdown isn't a sign of strength, it's the behavioral signature of a losing strategy. He's attacking the messengers because the message is devastating, and the intensity of his attacks escalates exactly as the line-drawing findings get more specific, especially in the fake elector, state pressure, and private lawyer categories. The rage is real, and it's proportional to the damage being done to his defense. The fake elector scheme is the clearest example of the immunity framework backfiring, because every single aspect of it, the organization, the communication, the execution, was done through private campaign channels. It's classified as unofficial conduct. That means zero immunity. and the evidence against it is the most detailed, the most specific, and the most corroborated in the entire case. So the strongest part of the prosecution's case is now the most exposed. The institutional channel they use to do it, private lawyers and operatives, is the very thing that makes it prosecutable. It's a perfect irony of legal strategy. The state official pressure campaign, highlighted by the recorded Raffensperger call, is the second clearest example. That call isn't disputed. It's a matter of public record. The only question was whether it was official or unofficial. The answer, under the immunity framework, is clearly unofficial. There's no federal authority for a president to tell a state official to change vote totals, and the call went through campaign channels. So the most publicly damning piece of evidence, the one that people remember, is now fully prosecutable. It's not protected, it's not immune, it's out in the open, and it's going to be part of the case. Trump's escalating meltdown is the behavioral confirmation that his legal team knows the immunity wall is crumbling. You don't attack the judges when you're winning. You attack them when you're losing and you have no other move. His demands to impeach judges, his accusations of foreign influence, his personal insults, all of it is a strategic substitute for substantive legal arguments that aren't working. The appeals process isn't going to save him on these specific acts because the framework itself places them in the unofficial category. So the only option left is to try to destroy the credibility of the judges making the rulings. It's a sign of desperation, not confidence. Here's what we need to watch going forward. Judge Chutkan's line-drawing proceedings are the most important legal event happening right now. She is systematically going through the indictment and making these official versus unofficial determinations. Whatever she decides will create the legal record for any future prosecution. If the federal case ever goes to trial, it will start from the foundation she's building now, where the most specific and most documented conduct is already categorized as unofficial and fully prosecutable. Meanwhile, the Georgia RICO case is moving on its own timeline, applying the same logic to the same conduct. The fake elector scheme and the Raffensperger call are clearly unofficial under any standard. So even if the federal case gets delayed, the immunity erosion is being documented in the legal record. The framework that was supposed to be a shield is becoming a map for prosecution. The bottom line is this. The Supreme Court handed down a ruling that gave Trump partial victory on paper, but in practice it set in motion a process that is systematically exposing his most criminal conduct. They said core official acts get absolute immunity. They said other official acts get presumptive immunity. But they said unofficial acts get nothing. And then they sent it back to the lower courts to draw the line. Now, that line is being drawn. And it's being drawn right through the heart of Trump's alleged conspiracy. The fake electors? Unofficial. The pressure on state officials? Unofficial. The private lawyer plots? Unofficial. The evidence that is most specific, most documented, and most damaging is being stripped of immunity, one act at a time. Trump's meltdown isn't an act. It's the genuine, documented rage of a defendant watching his legal protections evaporate in the very places he needs them most. He's attacking the judges because he can't attack the evidence. He's screaming about foreign influence because he can't argue with the facts. The immunity wall is not holding. It's being chipped away, allegation by allegation, determination by determination. And the framework that was supposed to be his total legal shield is now the very tool the courts are using to expose him. Stay tuned, because these line-drawing proceedings are active. The Georgia case is building. Every single development matters, and we are going to be here, breaking it all down as it happens. If you're not subscribed yet, hit that button right now. Drop a comment and tell me, does this line-drawing process eventually lead to a trial that a jury gets to see? Or does the sheer fact that Trump is president again block the most consequential accountability from ever happening? I want to hear your take. I'll see you in the next one.